Wisconsin currently has a law banning almost all abortions. It's been on the book for more than 170 years.
Capitol Bureau Chief A.J. Byadpour talked to the state's top law enforcement official, Josh Call, who questions whether that law would go right back into effect.
If the U.S. Supreme Court is indeed on the verge of striking down Roe v. Wade, Attorney General Josh Call says the fate of abortion rights in Wisconsin would still have to go through state courts.
Whether a law that has been dormant for essentially 2 generations would all of a sudden spring back to life is really an unprecedented issue. I think there'd be litigation over that.
Wisconsin still has a law dating back to 1849 that makes it a felony to perform an abortion. The only exception under that law is for cases where the abortion would save the mother's life.
I think you would see some challenges to that 1849 law, especially given that it is, so restrictive with no exceptions for rape or incest.
UW-Madison professor David Cannon says in addition to legal challenges, district attorneys would have to decide whether to prosecute individual cases.
It actually is up to the DAs in the 3 counties in Wisconsin where abortions are provided right now. Dane County, Milwaukee County, and Sheboygan County.
There's also the question of whether GOP lawmakers would want to tighten that law, something at least some Republicans support.
I believe that life is precious, and I believe that we need to do a better job as a state protecting all life and all forms regardless of how that life came into being.
So in those cases, you believe it should be illegal?
I don't support any exceptions.
Call says he will not direct his office to investigate or prosecute abortions until there's more clarity from the courts.
I don't think our Department of Justice should be using its resources that way. I also don't think that police agencies and DA's offices should be using their resources that way.